Before we start, for those of you who are new, this webinar is being organized by Moneylife Foundation. We are a 13-year-old non-profit organization primarily engaged in spreading financial literacy and advocacy for savers. We also make efforts to spread consumer awareness on various issues that are of interest to our members. In today's session, we are looking at a topic that has been of great interest to both cooperative housing societies and also to builders. Redevelopment has become quite popular since it is the most practical, economical, and long-term solution in a scenario where old structures are proving to be uneconomical or obsolete. However, there are many factors and questions that arise during the process, which have to be considered and addressed in a diligent and efficient manner at each step. So today we have invited Advocate Vinod Sampat to speak on the topic of redevelopment and to enlighten us on the intricacies and challenges that one might face when opting for the redevelopment process. Before we start, allow me to introduce our speaker. Advocate Sampat has been a practicing lawyer for over 30 years and has focused his efforts mainly on issues relating to cooperative housing societies. He has authored many articles on property-related matters and has written over 100 books on housing societies, transfer of flats, recovery of dues, registration and stamp duty, and other such matters. Before I hand it over to Advocate Sampat, allow me to share a few ground rules for today's session. We have kept all of you on mute for the benefit of all involved and will only unmute you during the Q&A session. For optimal viewing, we suggest that you keep the webinar on speaker view. This webinar is being recorded and shall be uploaded to our YouTube channel, Moneylife TV. During the Q&A session, please use the raise hands button available on Zoom if you wish to ask any questions. Also, a sincere request to please keep the questions short and to the point. Please feel free to the chat section to use the chat section to post your comments, questions, or observations. But do send it only to the public forum, marked to everyone. Please do not send us a private message as we will not be able to monitor or reply while the session is live. Please also note that your cameras may be on by default and you could be broadcasting your background and homes for everyone to see. If you wish to maintain your privacy, you may turn off your camera now. And without taking too much of your time, may I ask Advocate Sampat to please take over and start the presentation. Sir, over to you.
Good evening, friends. To begin with, I am thankful to Sujata Dalal and Moneylife Foundation for giving me an opportunity to express my views. The topic is conveyance and redevelopment of property. As you are aware, whenever there is any proposal for redevelopment, it is just as necessary that the property card, first and foremost, should be named in the name of the legal entity, which normally is a cooperative housing society. If you don't have the property card in your name, then in such scenario, obviously the person in whose name the property card is there, his consent is required. Now let us understand the intricacies with regards to getting the conveyance of the property. Say the cooperative society which wants to go for redevelopment has been registered in the year 1990. Now the building is old and we require the same to be redeveloped. When a proposal is being made, the municipal authorities recognize the person in whose name the property is standing. Many times it so happens that in spite of the fact that flat purchasers have paid the valuable consideration to the builder, for reasons best known, the builder does not transfer the property in the name of the legal entity. The reasons for the same are many. The builder wants to utilize the balance FSI, TDR benefits. They arise over a period of time. In simple terminology, prior to DP Plan 2034, FSI was 1, fungible FSI was 0.35. This is applicable in city. In the event the property is situated in Mumbai suburban area, the TDR was 1 and 0.35 was the fungible TDR. So in simple terminology, if your plot was of say 1000 square meters, 1000 plus 350 plus 1000 plus 350 equal to 2700 was the construction that was permitted. Now with the advent of 2034 DCR, the linkage of FSI TDR is linked to the width of the road. By and large, redevelopment of property is a win-win situation for all. But we should not forget one thing. When there is abundant stock, the supply increases, which in turn affects the standard of living of the people. Many of you may not be aware that in Mada colonies at Pantnagar and Vikroli, the potential of construction is 10 and 12. That means for a 1,000 square meter plot, construction that could be permitted is 10,000 square meter or 12,000 square meter, if one takes into consideration the tidbit and other benefits available. In fact, today the scenario in Mada is such that they are not able to utilize the full potential because of the restrictions in the nature of the size of the plot. At certain places, it is in the landing zone of the aeroplane. Practically in Ghatkopar, we face this problem. When you look at the concept of conveyance, as I mentioned earlier, the property needs to be first transferred in the name of the legal entity. When the building is going for redevelopment, the builder, the potential builder will say, you don't worry, I'll get the conveyance that from the earlier vendor. He will give his no objection. Obviously, that comes with the price. Here, the earlier builder who had already done his construction and is supposed to get the thing done for free gets a premium. Let us analyze the stages of conveyance. You can get it through the court of laws by approaching High Court. You can get it by approaching deemed conveyance authorities. You can get it by approaching consumer courts. You can also prosecute the builder for violation of the laws of the land. Deemed conveyance is a piecemeal situation where you go from one platform A to platform B to platform C. First, let me take the deemed conveyance aspect. You fill up a few forms at the office of the district deputy registrar. Needless to add that in my opinion, that involves speed money. After that, you have to go to the registration office. Their documents have to be signed. After that, you have to approach the city survey office. City survey office also may take out some technicalities. For example, the property as per city survey record is 10,205 square meter and actual certificate may be for 10,204 square meter. But this 1 square meter difference will make you go back from pillar to post to the earlier office, get those records rectified. Then again go for registration and then get all this procedure redone. We have seen a lot of complaints in deemed conveyance. Many times it so happens that you get the first ladder, you climb the first ladder, then the concept comes of payment of stamp duty, which results in a limbo as people are not willing to pay the proper stamp duty. So you have a paper tiger, a piece of certificate, which is nothing more than a paper tiger. But if you are approaching consumer courts, and we have seen that even the increase of stamp duty has got to be paid by the builder. When you go to consumer courts, the prayer will not be just for getting the conveyance of the property. It will be for getting the property card transferred in your name. That involves the formalities and modalities connected with getting the records transferred at the city survey office. Original document, as a legal entity, cooperative society, you must have the original documents of the title to the property, the property card, the property tax bill should be transferred in your name. The water bill should be transferred in your name. Section 11 of the Maharashtra Ownership Flats Act clearly stipulates that promoter to convey title, etc., and remove all the defects related to construction, related to the statutory obligations. Normally, the builder will show, see, look at this agreement. You have agreed for this, you have agreed for that. Well, agreement is nothing but a contract. It is a contractual obligation. What is written in the statute is the statutory obligation. And whenever there is a conflict between a contractual obligation and a statutory obligation, obviously the provisions of the statute will prevail. So even if you have written something in the agreement, you don't have to worry. There are various statutory clauses in the statutory clauses wherein you are protected. Under the Maharashtra Ownership Flats Act, we have the model agreement. Model agreement stipulates very well-defined clauses. You cannot have an agreement as per the sweet will of the builder. Government has specifically stated that these clauses are statutory in nature and you cannot supersede those clauses. Presuming for a fraction of a second, you have not written those clauses in your agreement, by the builder does not write that agreement, then also those clauses will supersede the provisions of the contract. The builder may write XYZ clauses, and if that clause is conflicting with the statutory clauses, then obviously the statutory clauses will supersede and that will be implemented. One of the classic things which we have seen is builder does not include the owners of the property as a party to the document. What is the reason for him not doing so? As you know, builder and the landowner, they enter into some transaction. And if the landowner is implicated as a party to the agreement, he may not come for registration. The bankers will not give a loan. From my experience, I have seen even the big sharks, they overlook many things wrong by the builder. And one classic example is the banks. For a small purchase of a flat of 2 BHK, 3 BHK, they will ask you so many documents of title. But when it comes to builder, very conveniently, the practice is ignored of the statutory obligation. The law stipulates that the owner of the property should be joined as a confirming party. This is very clearly mentioned in black and white in the Maharashtra Ownership Flats Act. I have no hesitation in saying that in spite of this clause openly being revoked by openly being flouted by the builders, banks are more than willing to give loans to the builder or the flat purchasers. They know it very well that this is a mistake being committed by the builders. But as the saying goes, the king is right. In spite of they knowing that this is the wrong thing being done by the builder, yet they overlook it. The second thing which is overlooked is the model agreement categorically stipulates under clause 4, I think, that the builder, when he is constructing the property, he has to mention specifically in black and white what is the FSI potential of the plot. If the builder mentions that FSI potential, obviously he cannot construct more than that. So definitely and intentionally, this clause is violated by the builders, and they don't write many clauses which are compulsory in nature. If you look at the model agreement, when you are purchasing a flat as a flat purchaser, you are paying certain amount not just for the four corners of the flat, but you are paying certain amount for the common areas and amenities appurtenant to the premises. The implications of the same is open parking, stilt parking, all such open spaces, terrace flat, the terrace area, all these things belongs to the society. But what does the builder do? He takes something extra for a person who is taking parking space, and that goes sweetly in his pocket, which he is not legally entitled to take. Now, with the advent of RERA, this certain amount of this common area, this type of things are legally being permitted to be sold. which in my view is not correct, but we all know how builders are. A plumber requires a license, an electrician requires a license, but all that a builder requires is a sweet tongue and a smiling face. He does not require any license. With MOFA, education is there for estate agents. I am of the opinion that more education is required by the builders community because they do so many wrong things within just to profit them. There are observations of the Supreme Court in the case of Rents Colony, wherein the judge, when the Supreme Court has gone on record to say that it is common knowledge that builders builders flout the laws of the land, and when such things are being done, one can safely presume that they have done it. They may have done it intentionally because builders are supposed to know the laws of the land in a better manner. This has been these are the observations of Supreme Court in French colony judgment. We have seen so many projects which are getting stalled. We have seen so many projects where builders have failed to comply with their promises. What is the best way to protect your interest? The best way to protect your interest is appoint a good lawyer when your society is going for redevelopment. Irrespective of the fact who is your lawyer, you need to take a few precautions. One precaution is there should be an exit clause in your development agreement. Supposing you have entered into a redevelopment agreement with the builder, it has been stated that the project will be completed by 3 years, within 3 years. He may demand grace period, say 6 months. So you should be very firm and ask a question. What happens after 3.5 years? Very politely and innocently, the builder will say, I was paying you rent of say 50,000. Now I'll pay you rent of 55,000. The next question from your side should follow is, okay, I give you 6 months more time after 3.5 years. Still you have not completed your project, then what? He will try to give evasive replies, and you have to be very firm and have to insist that there has to be a termination clause in the agreement itself, so that at one point of time, you are free like a bird. Experience shows that many times, knowingly or unknowingly, the managing committee members fall for the trap of the builder, and at times they are also corrupt. There have been so many instances where the builders are in collusion with the managing committee members and the project suffers. Second precaution that requires to be taken is when you are going for redevelopment, be blunt and ask him what is the maximum construction that will be done by the builder. The maximum construction should be put up in black and white, because he will always portray a picture that he is not getting much profit and hardly there is any scope. The length and the breadth of the plot are fixed. On the basis of the length and breadth of the plot, the construction is done. But there are so many incentives available. As I mentioned to you, the FSI can be 10 and 12 for MADA plots. It is slightly the subject of an architect, the built-up area, everything. I will tell you something very unusual, which you will also be surprised. If you do a phone call of ₹1, there is a very good authority like TRI which supervises and monitors. RERA is still a baby which has got a lot of handicaps which have got to be removed. And the best example of it is its orders are nothing more than a paper tiger, because it is not acting in a harsh way against the builder is in the last few years, which all of us know. Builders don't take RERA that much seriously because it has not started showing its teeth. The need of the day is to levy hefty penalties on the builders. Put them behind bars. Then only the lessons will come in the appropriate manner. Today, builders plead before era that if anything happens to my this thing, the whole project will suffer. And in spite of one or two flat purchases being done a wrong thing happening to them, others will suffer. And RERA is also lenient on builders, which we all know. Now coming to the aspect, as I mentioned to you, harsh questions should be there on the builder. The best thing is insist always for lead on the plot. Supposing on the plot of land which belongs to the society, 10% of the constructed area should be allowed to be sold by the builder only after he has completed the project and has obtained the building completion certificate. Earlier, no one was obtaining building completion certificate and they used to obtain occupation certificate. What was the reason of not obtaining the building completion certificate? The reason for obtaining the building completion or not obtaining the building completion certificate was the deposits that were lying with the municipal authorities were, say, of 5 lakhs rupees. And the cost of obtaining building completion certificate after getting occupation certificate was more than 75 lakhs or something. We all know, if I have to put it in a very humorous manner, BMC, as far as builders viewpoint is concerned, or the common man's viewpoint coming, of course, it is to some extent with the element of humor in it. BMC stands for Bachelors and Masters of Corruption. You will find expensive cars at the offices of building proposal departments, where I am told 8-digit amount could also be involved just to get the building completion certificate. Whether it is right or wrong, I don't know. But this is the general impression. If you go for construction of a building, there are so many things that have got to be complied with. Let me put it to you that even for ladies working there, crutches have got to be provided. On a plot of land where building has to be constructed, it is difficult for the builder to create so much space. So many times they ensure that their violations are overlooked. Your agreement, as I mentioned, should be a watertight agreement, leaving no scope for play. You have to be very harsh. Where are the normal plays being done? The normal plays being done by the builder is a series of promises are given verbally. Okay, don't worry, I will take care of it. So I will look into it. If your relative wants a flat, I will give some discount. And we have seen flat purchasers, the office bearers, knowingly or unknowingly, they fall for a trap with the builder. Humorously speaking, builder, यानी बिल का कभी डर ही नहीं होता है. Buy back, buy from me, see my back. Leakage, it is guaranteed. Leakage तो guarantee है, आने वाला ही है. 24 hours water. You will get water either from the wall or from the tap, but water you will definitely get. And last one is builder की सही पहचान, माप में ही पाप है. Carpet area, built-up area, super built-up area, sellable area, all these are terms utilized to make small area look bigger. I will not say that builders of India are not following the laws of the land. Some of you might have read in Times of India first page that the builders in USA have even started selling land on moon, as if they have themselves visited the planet, the moon, and they have seen that thing. But this is the ground reality which is happening. So, as a flat purchaser, as a member, you have to be extra cautious and you have to see to it that whatever you are going for, whatever commitments are being made by the builder, he is honoring those commitments. For all those things, what you require is an agreement which is foolproof. You should not allow morality to come in picture when you are documenting, when you are executing an agreement. It has to be a watertight agreement. One tip I would like to give to all my listeners is, whenever you are going to a builder's office or you are calling a builder, get everything recorded in black and white. Don't trust or don't let them talk to him as if in good faith. You have to ensure that everything is done in black and white, properly documented. One common thing which we have observed where the society fall in a trap is, it is said that if there is any dispute, then the matter will be referred to for arbitration. And let me tell you, arbitration is not easy. As a lawyer, I know the implications of it. So I always tell my friends, well-wishers and clients that always have a clause in the agreement that in the event of there being arbitration, it should be done by a retired judge. And the cost of arbitration has to be borne exclusively by the builder, and some fund should be taken in advance from the builder. We have the circular with regards to redevelopment issued by the cooperative department. But let me tell you, cooperative department, in my opinion, is cooperative. They don't monitor a thing once they give permission to the builder. They think that by giving the permission, their work is over. It is very, very difficult to get good output from builders because, number one, flat purchasers are not an organized community. They don't have legal knowledge. They easily fall for trap. In construction line, there are 1001 items. So if you ask for 10 items, the builder will go on speaking yes, because he knows that in other items he can easily cover up. If someone says, I'll give you A grade material, you will be happy. But in building line, C grade is better because it stands for quality. If A grade means it is not up to the mark. It is very difficult to see, it is very difficult to analyze which material is good or not. That requires a lot of experience, and unfortunately, managing committee members are not that much experienced. I explained to you the implications pertaining to conveyance, why it is important. We can get conveyance in a short span of time if you put the proper pressure approaching consumer court and the metropolitan magistrate's court. Definitely there can be a good amount of pressure. If you are fighting a case as an individual, High Court says that if the person who is fighting a case is more than 60 years of age, then an application can be made to the court anywhere in Maharashtra to expedite the court hearings. These things are not known to many, and in spite of the fact you being senior citizens, you don't take advantage of things which you are legally entitled to take. When you put up such things, the chances of you getting justice are slightly better, in my personal view. When you go for consumer court case, it may take 3 to 5 years. But when you are going along with a criminal case, there is every probability that he will come for a compromise. You should know how to attack the builder. You can dig up, you can use the power of RTI. Find out the track record of the builder, how the other buildings have been constructed. Statistics shows that not even 50% of the buildings in Bombay have the building completion certificate. 50%, I'm exaggerating. Not even, I would say 30-40% of the buildings have this as the building completion certificate. You look at the scenario, 1963 Ownership Flats Act came, 1947 we have got the independence, and now we are in 2023. So you can count the number of years, but still As far as conveyance of the property is concerned, it won't be more than 20-25% of the properties have got the conveyance of the property. For a 1 rupee telephone call, we have a good lobby and a good system of check, which ensures that phone call of 1 rupee is properly monitored. But here, crores of rupees are parked in real estate, but we don't have a very powerful lobby of flat purchasers. No wonder, we all know, politicians also park their funds in the nature of being a builder or in having partnership with builder or some collaboration with builder. Real estate, for some reason, since independence, is linked to a place where you can park your funds in a very safe manner. Earlier, the returns were also good. And if you go to a builder or speak something, builder will say, okay, I'll give you back your money. By the time you purchase the flat, and by the time you go to him with after 1 or 2 years, 3 years, the prices would have skyrocketed. Not to mention the fact that there was a possibility of cash being exchanged earlier at the time of booking. So always from day one, you are at the mercy of builders. As a flat purchaser, when you are purchasing a flat and staying in a cooperative society, you have to ensure that the said property, you get the title to the property. You have to remember two things. Either the property is freehold or it is leasehold. If it is freehold, you get the conveyance of the property. If the property is leasehold, you are entitled for lease a deed of assignment. Say the lease is of 99 years. Building is constructed by the builder and 15 years have passed. Then you will be entitled for the assignment of the lease, 99 minus 15, whatever it comes to. That is what one of the differences which we see is not properly utilized. Some builders, to put pressure, when they are selling the property as a lease, they give a lease to the sister concern, and when you go for redevelopment, they say that sister concern also has got a right in this property, so you have to pay some such amount to the sister concern. As far as redevelopment is concerned, before we start with the redevelopment, I would like to share with you, there is a new concept that has come up is of self-development. Friends, it is not easy to go for self-development. How many of you are aware that when you go for self-development, 3% stamp duty has got to be paid as per Article 25A of the Maharashtra Stamp Act? This is invariably not told by the project management consultant, PMC, whom many humorously called as Pura Malai Kamalo. This 3% is on the society. Builder or the PMC is a visiting faculty in the life of the building, and obviously in a 4-5 years from now, he will go away. Once the builder goes away, the right being annexed, attached to, or the stamp authorities are bound to recover the same with 2% penalty for the period for which the duty has been evaded. So this is one point which we have to keep in mind. Secondly, for redevelopment, you need technical experts. It is not easy. The concept of redevelopment looks very attractive. Banks were also earlier giving loan. Again, they stopped it. The Reserve Bank point of view, also some restrictions came. Many builders defaulted and they call themselves PMC and so on. Those things are there. But I will not advise you to go for redevelopment. In my view, in the whole of Bombay, not even 25 projects of redevelopment have been completed till today. If I am wrong, I would like to be corrected. Similarly, I will say the agreements that are being drafted under MOFA era and now the RERA era, I will say they are not as per the statute, the way it is being drafted. The words are being intentionally distorted to favor the builder. Now, when you come for redevelopment aspect, proper research is very much important, and the best tool for you to get information is internet. Talk to your friends. The criteria of selection of a builder is also equally important. I can go on, but I have prepared the slides, and I will request Moneylife Foundation to start with the slides. Okay, come to the next slide, please. I'll go fast on the slides. The basic criteria with regards to going for redevelopment is the title of the property should be with you. That comes with property card. That is very, very important. I explained to you that if the builder, if your society has not got the property card transferred in your name, again the earlier builder, you have to approach consumer court as well as file a criminal case. The laws of the land are such that when a builder is executing an agreement with the flat purchaser, he has to implicate the owner of the property as a confirming party, so that the title of the property is transferred in the name of the from the name of the legal entity to the actual flat purchaser's legal entity, namely cooperative society. Pausing here for a moment, earlier, whenever the agreements were being done, the builder used to call himself a developer and he was paying 1% development agreement charge. There was stamp duty on development agreement at 1%, which was not the correct scenario in view of the fact that the developer was taking the money from the flat purchaser. So he was acting for all practical purpose as owner. Earlier, the stamp duty was 10%, and on development per agreement, it was 1%. But now, for the last few years, the government has made it uniform for the owner conveyance also, as well as for development agreement, it is 5%. And of course, the metro says 1%. But by and large, now what has happened is people, when they prefer taking conveyance rather than development agreement because it is not lucrative for the developer. Next slide. When you as a legal entity wants going for redevelopment, when you as a legal entity purchasing a platform, a cooperative society, you have to have the occupation certificate, building completion certificate, statement of account, conveyance, original documents of title to the property, and you have to see that in the property card should be in your name. You have also to see that the proper stamp duty has been paid by the builder. If you look at the fine print of the agreements being executed, you will get many masalas. Many times it so happens that the builders for the earlier transactions, they do not pay the proper stamp duty in spite of the fact that they are duty bound to pay the same. Next. I also mentioned to you that each and every flat purchaser under the MOFA era have paid money for parking. Builder had no right to sell open parking or state parking. Now the scenario in RERA is different. And RERA has tried to favor the builders, thereby rights have been given to the builders to sell parking space. Now, when you look at model agreement, clause number 4 stipulates that what is the FSI potential of the property, that has got to be mentioned in the statutory obligation. It's a statutory obligation, and it is compulsory to be mentioned, but very rarely builders mention the same in the agreement. Next. If you look at the model agreements under MOFA, it very clearly mentions that 1, 2, 3, 4, 5, 8, 9, 10, 11, 12, 13, and 22. This is the note to the model agreement, which is a part and parcel of Maharashtra Ownership Flats Act. When you will read it, you will see that these clauses are statutory and mandatory, and even if there is any departure, the same will not be binding or enforceable upon the parties because they are void, they have been issued. And note number 2 says that the owner of the property has got to be joined as a confirming party so that the terms and conditions are binding on the owner. Friends, if you are a flat purchaser and the builder has failed to comply with any of these conditions, believe me, friend, that these two are your Brahmastra. Many times the builders, when you take up these 2 points, he will come for a compromise and you may not have to see the judgment being delivered by the actual court. There is every possibility that after issuance of a legal notice itself, he will come to you for a compromise and resolve your issues. The answer for that is when you are executing an agreement with the builder, stamp duty is paid, document is registered. Tomorrow, if the owner has not been joined as a confirming party, you can tell the builder this is your mistake and now you pay the stamp duty. You purchased the flat 10 years ago and today the stamp duty is high. You will have to pay the said amount. Next slide. I am talking specifically about MADA societies because it has got different set of rules in the play game. Let's take a look at those. What has been promised and what is constructed is entirely different. At many places, builders don't give the agreement, they just give an allotment letter. That examples are Sakar Nagar, Tilak Nagar, Viproli, Pant Nagar. All these are problems near to the Ghatkopar central suburbs. These types of problems are seen. The reason behind not executing individual agreement is to save on stamp duty. Now, luckily, the government has said that if the development agreement stamp duty has been paid and all the flat purchases are implemented as a party, there won't be any stamp duty. You will get a set off. But that was not so in the earlier years. Next. There are judgments that occupation certificate is a must. There is one judgment which says that maintenance charges should not be collected till the receipt of occupation certificate. Personally, I don't agree with this judgment. In my view, in spite of the same judgment being in existence, that will not be the correct stand, is my personal view. I also already mentioned allotment letters given, individual agreements not given, but that is a statutory obligation of the builder. RG stands for recreational ground. We have seen some buildings coming up in recreational ground in Shambur area, where that recreational ground is meant to be kept vacant so that children and old come and they can utilize that spare time, sitting there, relaxing there. But builders for the profit, they many times construct buildings there also, which is not correct, and it definitely affects the lifestyle of the people who are residing in the said area. Whether it is MADA or elsewhere, once you have handed over the plot of land to the builder, very rarely you will see cooperation from the builder. They, in the first instance, they don't respond to you, and they don't even literally. I would say they don't care for the flat purchases once possession is received, and they will not deal with you. They will just tell one of the secretaries or one of the sales girls to talk to you. Yes, sir. Yes, sir. Yes, sir. But they don't give much importance to flat purchases once possession is obtained in redevelopment matters. Is what is the experience of quite a few people. Next. Now let us take a look at the problems which are being faced at the time of redevelopment. All promises are made. Builders do not have funds. They talk very big, but when it comes to investing, it is not, the desired funds are not there. The market scenario cannot be predicted, which results in a situation where the whole game of the whole plan schedule gets upset. Many times we have seen managing committee members are themselves having vested interest. At times it so happens that everyone is promised X area in MADA, but that one does not fit. So one flat is on one room is given to X, one room is given to Y. Federations are not formed, stamp duty implications are not understood, tax implications, GST implications are not properly understood. Some people say we want money at the time of redevelopment, specifically old people. But there are some people who say, no, we don't want money, we want extra area. Obviously, as a builder, it is not possible for him to please everyone. Now, what are the standard common solutions to the problems? Let us see that. As I mentioned you, for agreement has to be watertight. The rights have to be properly protected, and if necessary, you may have to approach the court of laws. It is very difficult to terminate a builder because at the initial stages, you have not taken the proper precautions. I mentioned that agreement, the arbitrator should only be a high court judge. Bank guarantee is not taken, and even there is a play in the word of bank guarantee. So when you go to the bank says, sorry, in these conditions we cannot give. As a cooperative society, I would suggest that always don't give importance to the monetary compensation on the area. Only deal with builders with a good name. Projects of builders should be registered under ERA. That is also equally important. For example, builder says, I will give you the building in 3 years. But what is going to happen in the 3 years, that is not understood or properly assessed by the flat purchaser, because 3 years time is given. When will the first slab come? When will the second slab come? That bar chart plays a very vital role. Next. When you go for redevelopment, you require for July 2019 is the redevelopment circular issued by the cooperative department. Personally, I feel that this circular is not that much compulsory. There are high court judgments also pertaining to the same. But as you know, this could be one of the tools whereby some government officers would be more than willing and eager to implement these circulars for reasons best known, how cooperative some cooperative officers are. Now let us go for the process of redevelopment. We'll skip on to the elementaries. Yeah, next slide. Next slide. Next slide. As building gets old, we have to either replacement money or repairs, or we have to give a fresh look by reconstructing. The law stipulates structural audit has to be done for buildings above 30 years old, but very few cases this is done in a proper manner. There are buildings that are lasting for more than 150 years, like the BT railway station. But if you look at an average building today in years, 40 years, 50 years, that's the end of it. Now let us look at, analyze the advantages which occur due to redevelopment. What was constructed earlier and what is there now, there will obviously be a difference. Monetary incentive is that extra area, modern amenities, a planned layout, the new concepts, gym, etc., sauna, jacuzzi, big entrance lobby, all these new concepts are coming, and if it is a big society and with open space, more open space, these things can also be planned. Let's look at the process of redevelopment. We have to see how the things are going to go for, call for the general body, authorize of this particular meeting, the call, see the views of the members, take appoint a good PMC, managing committee, circulation of a special general or a general body meeting to be called, details to be uploaded on the website of the department. A common question that arises in society is quite a few members object. As far as redevelopment is concerned, 51% members majority is sufficient. If the builder is not cooperating, or if some members are not cooperating and trying to harass the builder, definitely they will not succeed. And indications to this effect are even given by the high courts from time to time. Just because of 1 or 2 persons of small minority cannot solve redevelopment. the works which are being allotted has to be watertight, including that of the PMC, because otherwise project management consultant don't take proper precautions और ऐसे ही कहा जाता है कि ये तो पूरा मलाई कमाल वाला है. Of course, that is for a sense of humor this is being stated, and don't go for any type of verbal consent or anything. It has to be specifically done. The modalities have to be done. I'm not going much onto it. That the PMC has to be appointed, meetings have to be called, explanations should be given, comparative analysis should be done. Next. The meetings are being called, feasibility report is prepared, draft tenders are prepared. Next. As far as possible, I have already suggested video shooting should be arranged. Everything should be done with the utmost transparency. Here I would like to emphasize that we talk of bylaws in a cooperative society, but in the eyes of laws, bylaws do not have the force of law, which many are not aware. Just to give you a few examples, it's a common misconception that if I am a defaulter, I cannot sell my flat. Society won't transfer it. In the eyes of law, it is sorry. Even if a member is a defaulter, even if there is unauthorized construction, society is bound to transfer the flat. Second misconception is nomination is there, then only society should transfer the flat. Supposing I have made a nomination in favor of my son A, and I have not given the nomination form to the society. Legally speaking, even if I have not given the nomination form to the society, the contents of the nomination form are binding on the society. This is the view of the Bombay High Court in the case of Paramount Cooperative Housing Society. Only thing is, High Court says that it should not be too much of technical. Only that should, the condition that was put up by the High Court was that there should not be dispute among the legal heirs. Next. Here is what is being stated on the modalities that has to be complied with. Bank guarantee has to be given, which also experience says they don't give it in that particular manner. The development agreement and power of attorney have got to be registered. Now we have got Marera carpet area. The exact carpet area has to be worked out. And carpet area or around roughly, I would say, the carpet area as per MOFA and carpet area as per Marera. The carpet area of supposing Marera is 100, the actual carpet area and the MOFA would be 110, roughly. Development agreement right should be non-transferable. So all these are the technicalities. Yeah, you can go one by one slide. Next slide. Next slide. These are some of the documents which are required, of course. Here I would like to point out one more thing. When you are going for redevelopment, the society should always insist for executing an agreement on as is where is basis. Society should not take any side sort of responsibility. In the event they take, there are so many members in the society, and definitely somewhere or the other they will get caught in. Next. 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 Well, friends, I could have said this thing more, but I had to ensure that the time that was allotted to me was 1 hour, and in 1 hour I have completed my part in 58 minutes. I am thankful to all of you for giving me a patient hearing. I will try to take up questions being raised by our viewers.
Thank you so much, Vinodji. Excellent presentation as always, very bold. And we really thank you for coming here and doing such a concise presentation. There are lots of people who've been waiting for this for a very, very long time. I'm glad we could do this. Akshay, you're going to read out some of the questions and ask them?
Yeah. So
That
I
would be
have.
faster. So let's go through some questions which you ask, and then we'll do the raised hands.
Okay. So there's a question. There's a question from Joseph. He asks, we have obtained deemed conveyance in favor of our society. We have the deemed conveyance under the deed of assignment. Landlord gave the property on lease to the builder for 99 years, and the builder has constructed the building and sold the flats. But both the builder and the landlord do not exist. There are no heirs of the landlord. What happens to the deemed conveyance or the deed of assignment after expiry of 99 years?
See, whenever you are going for, as I mentioned, property is either freehold or leasehold. Lease cannot enhance the life of this thing. Just because you have taken a lease of 99 years, that does not mean that the building has to go lock, stock, and barrel to the earlier owners. Let me give you one example. Queen Victoria had executed the lease deed for Taj Mahal Hotel and those areas for a particular period of years. Obviously, that period of years has got over. That does not mean that you can you have to hand over the land, lock, stock, and barrel to the original owners. But there are so many restrictions. So whenever there is a properties on lease, definitely it's like comparing gold and comparing silver. Obviously, gold, which is freehold land, will have a higher rate. But leasehold is also good, reasonably good enough. They depend on the lease deed. There may be a clause that they will execute they will enhance the lease deed. That is what the BMC is doing. Earlier, the lease was for 99 years, and they made it for 60 years, and now we see lease deeds of 30 years. But definitely, if you have to purchase any property, I would say you should go for that. And there is ample harassment being caused to BPT land, where the lease are renewed just now, just for a period of 5 years.
Okay, I'll read out the next question from Shankar. He says, if the conveyance is not done, if the conveyance is done, but the property card is not updated, can the society ask the developer to do it?
Society can always ask the developer to do the thing, but it's like putting it like expense which is of say 1 lakh rupees. The developer don't mind spending 10 lakh rupees, and ultimately what you are going to get, you will get less.
Right. There's another question from Shankar. He asks whether, in case in the death of a member, can the nominee sign individual agreement with the developer for redevelopment?
The nominee is just a custodian of the property. When a member has expired, it is the duty to get the appropriate letter of administration, or in the alternative, legal and family settlement, something to be registered. From the developer's point of view, he is more keen in getting the property redeveloped. So if he goes and asks for 10 people's signature, there will be a lot of hue and cry. But merely because the nominee has signed, that does not mean it is fulfilled. All the legal have got a right in the flat. And as far as development is concerned, just because 1 or 2 people are not signing won't make a difference. We are pausing for a moment. I will draw your attention to 1 or 2 practical problems. We observe that many times people are purchasing flat in a cooperative society. They do not have the funds with them. So they mortgage their interest with the bank and take NOC from society. At that point of time, when the society is going for redevelopment, these bankers say you refund us all the entire amount. If you won't give us give back the entire amount, we will not give you NOC. Or they may even compromise as if they are obliging you by telling you that you gave a security of 5 crores. Now you give us another security of 5 crores, then we'll release the security on this flat. So these are pressure tactics, things even done by refined and sophisticated institutions like bank. So I always tell my clients that whenever you are giving any NOC to a bank, you have to ensure that your interest is protected in a proper manner by making a condition in that NOC letter that first right on the property is mine. For example, tomorrow that member goes bankrupt. The bank will say, I have got my first right because I will lien on the property, but not the rights of the maintenance of the society. Similarly, when the society wants to go for redevelopment, the letter which you are giving to the bank should be conditional letter that first we will have a right on our dues, and in the event our dues are not cleared, then this lien won't be effective. That way you have to protect your interest.
We have a question from Vinita ma'am. She's raised her hand. I'm unmuting you.
Yes, yes. Yeah. Good evening, Vinita ji.
Yeah, good
Pune is full of your noble works, like Sucheta ji is here.
Thank you so much. Good evening. And your talk was just brilliant. But in the beginning, I missed some of the things, so I don't know whether you covered it. But in our case, we are having a very unique problem wherein the society's redevelopment has still not even reached any first stage. But some of the managing committee members, all four of them who are real estate agents, they are behind our backs calling all developers and trying to do the redevelopment without a knowledge. So we have sent a legal notice to them and approached the sub registrar. I want you to throw light on, the transparency that the managing committee also should adopt even before all this redevelopment, happens.
Good evening to you, Vinita ji. In my
Yeah.
book on cooperative societies, I'm sharing the same right now with Moneylife Foundation, with the
Okay.
request that you can freely circulate it to anyone who wants it. I have
Okay.
defined committee as a group of useless people, in a lighter sense it is, a group of useless people discussing useless issues with an
Right.
assured return that nothing is going to come out of the discussion. As we know, in
Right.
cooperative societies, there is
Yeah.
a lot of corruption and there are a lot
Yes.
of things which are overlooked.
Right.
Apart from that, when we see in managing committee,
Right. Yeah.
sorry.
Okay, thank you. I will go
Akshay,
through that
no, no,
booklet.
and
Thank you so
yeah,
much.
I'll just tell you, I've sent the book to Sujita ji and the team member.
Sure.
Now, what I, as an individual, I would say, in a cooperative society, the beauty of cooperative law is one for all and all for one. If you have a
Right.
power of attorney, you can do many wonders, but you cannot attend the general body meeting of the society.
Okay.
Now, as an individual member, you can ventilate your grievances at various levels, be it a society managing committee, be it a society general body level, you can be it the registrar, cooperative court, or other courts. But
Right.
specifically for your problem, I would like to suggest that the cooperative department has given directions that video shooting should be done of the managing committee meeting, and the video shooting which is being done is already said. Video shooting which is done, the same should be given to each and every member of the society.
Right.
So whether you attend the managing committee, whether you attend the general body meetings or not, just to keep track of what is going on in the society, you have to ensure that whatever is happening in the society, you get come to know about it, which can easily be monitored when you go through the video shooting.
Right.
Video shooting. So this is one thing which I strongly suggest you should keep in mind. The circular of video shooting has also been sent with Sucheta ji, with a request to circulate the book as well as the video shooting circular to all the members, because at some point of time you will find it very handy and useful.
Right. Thank you, Ji. And I will go through that and later speak to you because there are many other questions also. Thank you so much. Thank you.
So much.
Namaste.
I'm unmuting Sashi. You can ask your question next.
Yeah, thank you. Sir, my question is, a process that has to be followed, like deputy registrar's official had come in the presence and video recording, everything was done. But what happened was majority consent as per the 79A directive was not there. Like one member, one vote, and one single member, he was not there. So his brother came and signed. Lots of wrong things have happened. So is this forgery as per Indian Penal Code? And the DR's official who was there, in whose presence this happened, can I file a FIR against him also? Him and the committee? Kindly let me know.
My request to you is, first and foremost, as I mentioned to you, the video recording, you should always ask for the meeting's video recording. That will help you get the records. I will tell you from my experience, cooperative department or officers or any government department officers, invariably seniors of the department protect. And this is seen by no one else except even the Anti-Corruption Bureau, they agrees with this particular stand. You don't get the right permission immediately. Now, definitely in your personal capacity, you can take up all these issues. I will tell you that registrar's office, they won't be much affected by all this thing because it is very difficult to do and they help each other. The word Kal in Hindi stands for yesterday. The word Kal in Hindi stands for tomorrow. So if you have got the dashing desire to punish and criticize and take up these officers head on, with the passage of time, there is a probability that you will lose the steam. And hota hai chalta hai concept gains so much importance. I just ask one simple question. When we have so much technology at our hand disposal, why should there be a need for any individual to go and visit the office of a government officer? You sit in your chambers and at desired time, you go and talk to him via this particular technologies like Zoom, WhatsApp, etc. Here, bulk of the time people get frustrated with these government offices. Half the time they are not sitting in their cabin. And even if they are sitting, you have to wait for a long time just to say, okay, I will look at it. My experience of cooperative and other officers is they are very sweet talkers. When you go, the biggest asset or knowledge is to convince a person who has gone with the boiling point to bring him back to normal and not do the work what is there because they don't have the time. To some extent, government of us is also to be blamed. As per the internal information received by me, I am told that in some government offices, even computers and stationeries are purchased by the officers because government does not give them funds. This is the ground reality as per my information.
We'll go to the next question. Vipul Kala, I'm unmuting you. You can ask your question.
Thank you. Thank you for giving me opportunity. Sir, I have a question that we are planning for a redevelopment, and in our society we have flats where in some flats we have a balcony and some flats we don't have a balcony. So in current scenario, builder is giving a carpet area without balcony. He is excluding balcony. So what we can do in this case?
Well, as far as you are concerned, the resolution of the general body will prevail. Supposing there is an offer for, say, 20% extra, there is an offer for 25% extra, and there is an offer for 30% extra. If general body decides to go with 20% extra area, that is also final and binding. It is not that one has to go for a offer which is very good from the financial point of view. What your general body decides, that will be the law of the land. Majority will decide. Yeah.
I'll read the next question. There's a question from Atik Sheikh. He's asking, can we terminate redevelopment MOU if the builder is not doing anything even after 7 years of signing?
See, I will suggest to you one thing. You can 101% terminate the agreement, but that termination cannot be one-sided. It will have to be through the court of law, and that will take some time. My suggestion to you is when you read that agreement, apart from terminating, which is being done by the society, each and every member is a consumer, and the act of the developer and the society is an act of deficiency of service and unfair trade practice. My suggestion to you is as an individual members, you approach the consumer court and ask for heavy compensation from the developer. If an order is passed by consumer court and if it is not implemented, section 25 and 27 of the old Consumer Act and 71 and 72 of the new Consumer Act, you can not only claim compensation but put the builder behind bars if he fails to comply with the same.
Okay. Aditi Teri, I'm unmuting you. You can ask your question. Hello, Aditi. Aditi, we can't hear you. I think I'll move to the next question. We'll come back to you, Aditi. Atul Sampat, I'm unmuting you.
Hello.
Yes, Atul.
Yes, sir. I am Atul Sampat, sir. My building, we have appointed the redevelopment committee. Now the committee is taking a directly their decision without connecting to the redevelopment committee. So how can we solve this problem? And directly they come into the AGM. And second point is my building is already got the dim conveyance of only inside the plot. And outside the roadside, we are not connecting with the dim conveyance. That committee, what they have done the mistake. And now they are saying we take the additional dim outside the road dim conveyance, then the 22% to be paid extra and the builder will be more profitable to you. Otherwise, this building is not supposed to be profitable for the members.
See, there is a judgment of Sultanabad versus Mazda Cooperative Housing Society, which says that when you go for deemed conveyance, the RP areas, you will not get the conveyance. This is not properly appreciated and understood by many people who want a shortcut when they go for deemed conveyance. Now, as far as the decisions being taken by the committee, overlooking some other committee, the best course for you is to go to the general body, call for a requisition meeting, and whatever majority says will prevail over. But as a member, you ask for video shooting of all the meetings of the committee, listen what is there, and highlight your questions first to the society. Let them reply to them. If they don't reply to them, that amounts to a deficiency of service and fair trade practice, which you can take up in the court of laws. You have to prove that society is the committee is not functioning properly, and if financial loss is caused to the society by the acts of the managing committee members, then you can also take action under section 83 and 88 of the Maharashtra Cooperative Society Act against the managing committee members, and also go to the cooperative court for the appointment of a court receiver on the flat of the managing committee members. But let me tell you, all these things are time consuming, and we as public, we want quick results.
I'll read the next question from Sujay Nadkarni. He asks, what is the remedy where managing committee has bulldozed members and signed a developer agreement in which mandatory clauses mentioned by you are missing?
As I told you, individual member also has got a lot of power. If managing committee has bulldozed you and has concealed certain facts, you can take criminal action against them also, and also go for the appointment of a court receiver on the flat of the managing committee members.
Okay, I'll unmute Krishna Chand Yadav. You can ask your question. Krishna Chand ji?
Hello. Yeah, am I audible?
Yes.
Yeah. Very good evening, sir. Sir, ours is a MADA housing societies, and my flat carpet area is 180 square feet. And we have been approached by Darshan Jain builder, and he is promising us 525 square feet carpet area. And he has also mentioned about some cluster redevelopment under 33.9 and 33.7 of DC regulations. And apart from our building, there are another 4 buildings, and he has offered all the 5 buildings which are MADA housing societies. So is the offer area being given by him 525 square feet carpet to each one of us is okay, or I mean, how shall we approach him?
For that, you have to talk to estate agent and persons connected. The lawyer cannot help you on those points. My humble suggestion to you is do some proper research work. I gave you an example that in MADA colonies 10 and 12 FSI is possible.
Hello, sir. Good evening. My question is it beneficial for converting a condominium to cooperative housing society for future redevelopment deployment?
Well, both have got their strong points and weak points. Suppose if I am a flat purchaser, my group has got 90% of the premises. Then I'll obviously tell the builder I don't want a cooperative society, I want a condominium, because then the percentage share is linked to, then the share in voting is linked to the percentage of the property one has had. Definitely cooperative society is much beneficial, but it also depends on who the actual purchasers are. The beauty of cooperative societies is one for all and all for one. It is a combination of capital and personal participation.
Okay, I'll read off the question from Aditi. She couldn't connect earlier, so she sent her question in chat. She's saying our building is 50 years old. It got conveyanced in the year 1994. There are two members in our society who have complained last year to the sub-registrar that I and J register are incomplete by the managing committee. Because of this, the administrator has come into power. The administrator is now saying that the members should have all chain documents. Only then I and J register will be updated by them. Is this correct?
Basically, when you are a member of the society for such a long time, and the concept in mercantile transaction is bias bigger. Society has already issued share certificate to you. Then the administrator or whoever may be there is bound to endorse your name on the share certificate. So you have to check if the name of yours is there on the share certificate or not. And it is our experience that these administrators who are now called authorized officers, they try to complicate the thing unnecessarily. In all probability, that could be for speed money.
Okay, I'll take the last two questions. CG, I'm unmuting you. You can ask your question.
Question is very basic, and it's regarding a society in Pune, a society of only 12 members. So what is the total number of votes that we need to go ahead with the redevelopment plan?
51%.
And
51%, yeah.
Okay, Rohit Jadie, I'm unmuting you. This is the last question that we'll take.
Hi, my name is Rohit Jade. Thank you so much for giving this opportunity. I had two questions. Firstly, can you shed some light on amalgamation? Because a lot of times multiple properties are clubbing together. So in case of amalgamation of adjoining plots, if one of them is a cooperative housing society while the other is a private property, is it possible in the first place, and what are the aspects that need to be taken care of in such a scenario? Secondly, I wanted to know what is the GST rate, whether GST is applicable in the first place for existing members when the society is being redeveloped, and whether it is applicable only on the additional area or the complete area. If you could help me out. Thank you so much.
Both questions are good. First question is amalgamation of properties, one cooperative society, one private limited. Before I answer your question, I would like to share the provisions of Section 3 of the Maharashtra Stamp Act. Sections 3 of the Maharashtra Stamp Act stipulate that it is the instrument which is liable for tax. Section 4 talks in terms of several instruments executed to execute one particular transaction. It says that suppose there are multiple instruments, that only one document will be the principal instrument, which is the option of the parties, and all other stamp documents will bear a stamp of 100 rupees. Now, as a cooperative society, when your flat purchasers purchase the flat, at that point of time, all have paid stamp duty. But now, when you are amalgamating two properties into one, in my view, it attracts stamp duty, residential at Article 25D and commercial at Article 25B. Now, everything that is 5%. Governments are also lenient on this thing, but they are not taking stamp duty. But my personal view is that 5% stamp duty will have to be paid on this document. So amalgamation may be advisable from builder's point of view, but you have to think twice before going for amalgamation. My personal view is to both of you jointly develop the property as two separate entities and not as one entity. This is the answer to your first question. The second question is GST. Basically, GST is 7.5%. 1/3 is the abatement. So it works out to 5%. That is the GST that is payable on purchase of the flat. And for the resale component only, or the extra area component, it will be payable. But that won't be payable for the existing area or the benefit being given uniformly to all the members of the society. As far as GST is concerned, recently the Gujarat High Court has come up with a judgment. The sum and substance of the judgment is if the land is there, on that the GST component will not be applicable because it is a fixed, there is no sale or something. And that judgment of the Gujarat High Court says that hardly the implication is not even 2.5% GST will come. It is the special civil application number 1350/21 with special civil application number 6840. This is also a very informative thing, which I'm sharing it with the team members of Moneylife Foundation. Please, please share it with your all the participants, because here there will be a lot of inquiries, and this is one area where builders misuse their powers and misguide and exploit the flat purchasers. I have shared the same with Sucheta.
Thank you so much, sir, for taking the time to speak at this webinar and for giving such a detailed and extensive presentation. I can still see there are a few questions coming in, but unfortunately, since this is a webinar, we are limited with the time and cannot take any detailed queries on this forum. But you can still send your queries to our legal helpline. Links were posted earlier in the chat. So you can either post your query on the helpline, or you can even send us an email at foundation@moneylife.in, and we'll guide you to the helpline so you can get your queries answered online as well. With that, I'll close out today's webinar. Thank you all for joining us, and thank you, Vinod sir, for the excellent presentation.
Let me
I'm
just
obliged
add,
to Sujita for giving me an opportunity to express my views.
thank you so much. And I've got all the messages that you sent, and I will be happy to share them with everyone. Thank you so much. Wonderful.
In fact, I will request you, Sucheta, that this book of cooperative society, it is, I'm circulating to everyone, just as you are doing it. And friends, this book, whenever you have any question, elementary knowledge you will get from this question. Of course, it is an old book, but still the concept remains the same. By and large, in majority of the 75% of the cases, that same principle will apply. So if you just look at a topic, for example, general body, just search on Google, you just do control F on that particular book of 800 plus pages, it is there. That will give you some knowledge on that subject.
Excellent. We'll be
Sure.
happy to have that.
Thank you, sir. Thank you.
Thank you.